Okay, we've got a couple of people. We'll just give it another minute or two until everyone else has had a chance to log in. Hope everyone's had a good weekend. I know there's quite a few things on at the moment for Law Week, so I think it's a jam-packed schedule they've got. So it's always an interesting mix of people who attend these webinars, ranging from people in the academic space to other lawyers or lawyers who aren't really across IP and trademarks or people setting up their own businesses. So it's sort of really a one-on-one, 101 session on IP and trademarks just to give you guys a bit of a flavor and to be able to sort of issue spot a couple of items so that you know when to sort of move forward with a brand or with IP or when you don't need to. So we're at one pass. So I'm going to screen share now my presentation and we'll jump into it. So bear with me one moment. All right, so welcome everybody. I'm Rosalyn Gladwin from Gladwin Legal, and today we're going to be talking about IP with a particular emphasis on trademarks. And I'm very happy to have this as an interactive session. So if anyone's got any questions or wants to clarify something or jump in and add something, feel free to do so. I can see comments on the chat. Otherwise, happy to take questions at the end. Often referred to as IP. We have branding, trademarks, and copyright. And then at the end, we'll happy to take any questions. So what is IP? So you'll often hear a lawyer saying, oh, you need to protect your IP. IP is a really, important asset of your business. So IP is really how customers recognize your brand and your business and can also be assets of your brand. Like think about Coca-Cola and its trade secret recipe, its design registered bottles, its trademark registered name. And also, think about things like Panadol or medications, they have patent registration. So there's a whole host of IP, intellectual property registrations available to people to use. And it really just depends on what it is you're trying to protect as to what mode of IP protection you'll lean on. So most common is trademarks, and that's really your brand and your sign and what you're going to use to allow your customers and people in the industry to remember your business. The other thing is that having great protection for your IP can give you income if you have something that you can license. It can generate cash flow, and then if you're looking for investors or to sell your business in the future, then it can be used as a way to bolster the assets of your business that you're then selling. So and here, IPs, can be one of the most valuable assets of your business. Also, another thing that people often forget or overlook is that, customer lists can be really valuable and they're certainly IP of your business. So talking about branding, branding and trademarks are generally one of the first things people think about with their business. So sometimes people might develop a patent or develop a really cool product and then think, oh, now I need to brand it and think about it. Oftentimes people will otherwise think, oh, I want to start a really cool clothing business or I want to start a homewares business and this is the name or the type of business that I want. And, they come up with a really cool name for it. and they put that as the first point of call of their business. So often with business names and trademarks, they get confused. So business names are a registered name that allows you the right to go out and say, I am so and so. So, for example, take like David Jones. The name David Jones is obviously the name of the business. If a person was called David Jones, they wouldn't need a registered business name. They would just say, I'm David Jones running a clothing store. But if you have a company, so say Rosalyn Gladwin, I want to go and run a clothing business, I'm going to call it McDonald's Clothing. So if I then want to call it McDonald's Clothing, I need to then register it as a business name so that if there's an issue later on, people can track it back and say, oh, Rosalyn Gladwin is the owner of McDonald's Clothing. If you don't register the business name, which is a right to tell the world you're trading as something other than your personal name, there are fines that can apply. So often people will think, oh, I've registered a business name, so therefore I don't need a trademark. But a business name doesn't give you the right to stop other people from using the name. It only gives you the right to go out to the world and trade as a name other than your personal name or your company name. So it's really important to think about if you have a name that you want to stop other people from using, then you need to register it as a trademark because it gives you a lot more protection. There's a concept called common law protection. I'm not going to go into like the full legal nuances of the two, but common law protection is not registered, but it doesn't give you the same level of protection as having a registered trademark. So then when you're thinking about a trademark, it's really important to think about words and names that obviously are not used already, that you might engage a lawyer or somebody to do some comprehensive searches for you, whether it's in Australia or overseas. So you'll need to think about what's your aim for this brand? Is it global domination? Do you then need to check all your key countries to make sure no one else has that name? So a really famous example actually is Showpo. So they were called Showpony in the very beginning. And then it could have been America, but there was a country that they went to and Showpony was not available. So they actually changed the name to Showpo and globally changed their name because they wanted one consistent name. Another option is some people will have like a diffusion name. So they might have a name in Australia and then if in 2 years you go to America, their name's not available, you don't want to rebrand in Australia, brand that you would use overseas. So just some things to think about when you're thinking about creating your name would be making sure that it's not being used elsewhere. Thinking about a name that's not unique to your industry or descriptive. So, for example, one client wanted to register a trademark for a word that meant small in another language in relation to clothing. And IP Australia won't allow that because if you want to use the word small in relation to clothing, everyone's going to need to use that to describe what size potentially their clothing is, small, medium, or large. So IP Australia will not let you use words that are either in English or a foreign language that have a meaning in your industry. Take like, diamonds, for example. If I want to register a new trademark for diamonds and I think, the word sparkle or clarity, clarity diamonds. Clarity is a feature that's often associated with grading of diamonds. So you wouldn't get that trademark registered. So in thinking about those kinds of names, try and stay away from those words. Also, words like fair dinkum, g'day, words that are sort of common vernacular that other people might wish to use, or Aussie, or where the product comes from. So if you're saying like Melbourne Seed Company, it's unlikely to get registered because other people who sell seeds and come from Melbourne would need to be able to use that name. So they're also not good trademarks, leaving aside the fact that they don't get registered. From just a common sense perspective, if you have Melbourne seeds and if you have Victorian Seed Co., they're very likely to get confused between consumers because they're not distinctive and they don't tell consumers, hey, this is Bob Smith and he's Victorian Seed Co. So if you think about good trademarks, they have nothing to do with the product. Often, like, made up words are really cool because they're a bit different. Like, you think Shopo, um, Dodo Internet, um, Vegemite. They're words that, other than what they're now known as, they didn't really have a meaning or a common product association with them beforehand. Um, Obviously, the more unique the word, therefore need to put more money in to educate the market and tell them that Vegemite means this salty black spread that you put on toast. If it were not for the marketing, we wouldn't know what it was. So there's a bit of a balance for you to think about, how descriptive you get versus how unique. So often you might wish to have a word like Dodo Internet. So Dodo is obviously the unique word. Internet obviously tells people what they do. So you can sort of do a bit of a blend. So they're just some things to think about. So hopefully that gives you, a few tips on what to do when you're branding your business. So we've talked about, choosing a name that's not currently used by anyone else, whether it's registered or not. Because if someone else has been using a name, even if they're not registered, they might still be able to use it and you can't stop them, even though they might not prevent you from using your mark. And consider if you're going to use a logo. So some people, had one client who registered Fair Dinkum something something. It didn't get through. We'd suggested to him, look, it probably won't get through. And then what we did was we paired it with a logo to overcome the generic objection. Yes, he got it registered. Yes, he's got a trademark. It's a logo mark. It doesn't give him the same level of protection as a word mark, because if someone else comes as Fair Dinkum something something and has a completely different logo, they may still get their trademark registered. He may not be able to stop them. But sometimes I take the view that having it on the register can be a bit of a deterrent anyway for other people. So making sure that you can protect it, making sure it's recognizable, and making sure it's unique so that it gives you a unique brand proposition and you can stand out from your competitors. So if you've got your brand, you know what it's going to be called, you think, oh, right now I'm selling, hand knitted blankets, but I might decide to go to beanies. I might decide to sell knitting needles. I might decide to sell wool as well. So if I then register my trademark for all of those things, and then in the next 3 years, I only use it for the blankets, someone else could come along and say, well, you're not actually using it for knitting needles and wool. I'm going to challenge your trademark for non-use. They can then lodge an application for non-use, which basically gives them a month leeway. So I can't get that application and quickly then advertise it for knitting needles. So what then happens is I have the burden then of showing that I've used my trademark for all these other things. And if I haven't, then it gets removed for those items that I haven't used it for. So it's just a balance between thinking about what you're going to do in the next few years with your mark and protecting it, and not overprotecting, because also, it's not cheap. It can be really expensive to register a trademark, especially if you're looking at multiple classes of goods and services and multiple countries. So you do need to sort of focus on what is the most important. The other thing is that if you don't register your trademark, there can be people who register a trademark like domain squatting. Yes, you can challenge them for non-use, as someone could do for you, but the burden of proof is really, really low. So in terms of showing non-use, all someone needs to do is show that they've, done some advertising or some marketing or, generated some product or some flyers, and that would constitute use. So it's a very low bar. I had one client who had been trading for about 5 years in the healthcare industry, and she had a great brand name. It was really cool. It was really on point with her product. It was distinctive. Um, and her competitor opened up literally 3 doors down and registered an almost identical trademark to her name. Um, so what then happened was she opposed his trademark. Um, oh, actually, sorry, she'd missed the opposition date, so his trademark got fully registered, and then she tried to have his trademark removed on the basis that he wasn't the owner of the mark. She'd been using it first, and she had entirely valid arguments, and if it had gone to court, she probably would have won a court case. But at the time when she came to see me, she'd already been to other lawyers. She'd already spent like a couple of years arguing with this guy. I think she'd spent like $7,000 on trying to reclaim her brand and get him to have his name unregistered. And for a small business, that's a lot of money. And so it was at the point where we kind of needed to just, help her decide whether she continues to fight this guy who had really deep pockets and was going to fight her tooth and nail, or whether she just spend the money rebranding. And unfortunately, in that instance, she rebranded her business. And through I'd say through no fault of her own, it would have been prevented if she'd been, had registered her trademark in the beginning, but, she didn't know. So through no fault of her own, this other guy's maliciously come, pinched her trademark, registered a trademark, and therefore, got an earlier priority date. If she'd had a mark, then it would have been a non-issue. So sometimes, again, it's a balance between, startups don't often have limitless funds, and you do need to, be really wary of what you spend your money on, especially when you're bootstrapping. But having a trademark can, save you thousands of dollars later on. So sometimes it's a balance between you may not do it, on day one when you're registered, but maybe don't leave it till year 5. Think about in the first few months, is this business a goer? And, reinvesting that money on your branding. So again, like if you haven't registered your trademark from the beginning, but you've used it, keep evidence of use, because you can demonstrate if someone else comes to use your trademark or register it, you can potentially oppose it on the basis that you're the trademark owner, because in Australia we have a first to use system, not just first to lodge. But it's really hard because if someone lodges a trademark and you don't know that they've lodged it, then you're not going to be able to, put your hand up to IP Australia and say, hey, hang on, that's my trademark, I own it, when there's the opposition period. So you lodge a trademark, IP Australia reviews it. If they give it the tick, then it gets advertised for 2 months for other people to oppose it. And so during that time, that's when you can put your hand up and say, I'm the trademark owner. So if you don't register your trademark, another option might be, to engage a lawyer to do a watching service, so that even if you don't have the money to register it, maybe you might decide to just be alerted if anyone's using it. The only other difficulty with that is that if I'm, say, in Melbourne and I do, something blankets, whatever, blue diamond blankets, and someone in Western Australia or, somewhere else in Australia does blue diamond blankets as well, or they might say diamond blue blankets or something. What happens is if neither of them are registered, then you have this honest and concurrent use situation where both are allowed to continue using their brands, and you can't necessarily stop the other person, even if you then go and register your trademark. So that's why, whilst you don't legally have to register a trademark, there are a lot of complexities that could arise if you don't register it, if it's a brand that, has value moving forward. So another type of IP not registration, protection, is copyright. And I say protection, not registration, because copyright does not need to be registered. And we often get so many calls about copyright. So someone will say, I've written a song, how do I copyright it? Or I've written a book, how do I copyright it? Or I've made this really cool artwork, how do I copyright it? So you don't need to do anything. As soon as you've created something, you own the copyright. I own the copyright in this slide. I haven't done anything to to protect it. I've made it. I own it. So as long as you have created it, then you own the copyright. If, for example, you have an employee who's designed a dress for you, or a piece of fabric, or an artwork, or a song, it's really important to make sure that you've got great agreements that lock down the ownership of that and assign it over to you. So copyright can be assigned between people. So even if I created an artwork, I can assign that to someone else and then they own it. So under an employment arrangement, there's a general assumption that if something is created during the course of employment, that the employer will own it. There can be disputes. So if I'm employed by a fashion house and maybe at night I just do some doodling, I do some sketches of a dress, let's say we then create it within the business, there could be argument that maybe that's something I've done outside the course of employment, especially if it's not within my role of employment. So maybe I'm head of legal and I've designed a dress and I say, hey, let's have a go and see how this goes. Maybe there's argument that I own the design. Um, so it's really important to just make sure you clarify that both in your employment agreements, or what you can also do is have an IP assignment deed. So that's quite common for fashion houses to have for their designers in tandem to an employment agreement, just to clarify that anything they have or will design is owned by the business. And same with websites, computer programs, computer code. It's really important to make sure that they're assigned over, especially so there's that assumption with employees. But if you then have, for example, contractors that you engage, it's even more critical because there's not that automatic assumption that you own it. And then there's also, questions about, have you owned it if you haven't paid in full, or what if there's a dispute over the invoice? You don't want an invoice dispute to then, hold up or cause issues with your ownership of IP. So just some things to bear in mind. And, they might not be 100% relevant now, but, in 6 months' time, you might hire a designer to do something and you'll think, oh, I need to do something about the IP ownership. You can always get in touch and ask us what the right steps are. So sometimes people say to me, I've designed a logo. Why do I need to register a trademark? So yes, you would own the copyright in the logo, or if you have a trademark like Happy Little Vegemites, or a slogan like Just Do It, do you need to trademark that? So copyright automatically would apply in the slogan or the logo. However, it is a lot clearer if you have a trademark. It's a national register. The timing of copyright is the author's life and 70 years after their death. Trademark is only 10 years, but again, it's a searchable public register. So you wouldn't ever register a trademark over the text of a book or the text of a song. A trademark really is more just for the sign or insignia that makes your brand or your product recognizable. So for example, Harry Potter, I haven't checked, but presumably there's some kind of trademarks over Harry Potter or Hedwig the Owl, or some of the character names or concepts from the book, but there's no registration that would protect the book itself other than the copyright ownership. And it's always interesting when you see things like maybe it's Dr. Seuss, his books then become, a movie years and years after, someone has died or something like that. So, often that'll be because an author who maybe didn't want to do certain things with their product or their family, then loses the right to the copyright. And so then that, becomes more fair game and more commercialized after someone has passed away and that time period has been served. As I said, you need to think globally. So, with copyright, there's international treaties that apply. So having copyright in Australia will give you common protection in some other countries. Similarly with trademarks, so we are part of the WIPO, which is the World Intellectual Property Organization, and registering a trademark in Australia will give you a 6-month grace period in many other countries. So, for example, if I register a trademark today for that Blue Diamond Blankets trademark, but I think I might want to go to America, not quite ready to spend the money, then in 5 or so months, if I register it through the WIPO system using my Australian application, it actually backdates my Australian one 6 months. So just something to bear in mind, that if you're a couple of months in and you think you might want to go overseas, start thinking about that, but make sure you don't miss that 6-month window. And the reason why we also don't often do it at the same time as registering the Australian mark is that if it comes back that, oh, someone else has diamond blue blankets or whatever in Australia, or IP Australia has some issue, or someone opposes it, or they say, look, you can have it for blankets but not for knitting needles, then what happens is that international application gets undone. So there's a bit of a balance between at what point you register the overseas one versus the Australian one. But that's something, that we or your lawyer can help you with at the time of looking at, global domination with your brand. So other forms of IP, not as common for us, are design and patent registration. We do get a lot of inquiries about patents, but we refer them to a patent specialist. Often a patent attorney is someone who's also an industrial chemist or industrial designer, or someone who has a PhD in the area and can then look at, say, a chemical formulation and say, yes, it does have some unique proposition. So also, people often will call and say, I want a patent, but what they really want is a trademark. So the way to think about them is a design registration is the look and feel of something. So if you think about the Coke bottle with the curves, before the Coke bottle, people were using bottles for, 100, 200 years, whenever ceramics and glass moldings, were started to use. But the look and feel of that bottle, the look of it, is different to what came before it. So that's how they got their design registration. The Nokia phone, everyone remembers the old Nokia with the kind of, buttons with the leaf looking and the, shape of the screen on top. They have design registrations. Again, like the concept of a mobile phone wasn't unique, but the look and feel of their phone is unique. So that's design. Design is look and feel of something, and it needs to be really unique to whatever has been in the market beforehand. And it's really important, if you have a design for something, that you've not sold or marketed it before you go and lodge, because as soon as it's in the market, it no longer can pass the test of being new and novel compared to what's on the market. So we had a client who had a product, and it was an amazing product. She wanted design registration. She would have gotten it, but she'd already been trading for a number of years. And then within, a year or so of her wanting to do the design registration and realizing she couldn't, Kmart and Target were copying her product, and there's literally was nothing that she could do about it other than rely on her brand and her trademark as the well-known brand of this product, and that any others would be kind of cheap copies, hopefully relying on that. So design, look of something, patent, function of something. So patents will be, if you have a bottle and it's, a really cool, funky new bottle, it's not going to be a patent registration because receptacles and bottles already exist. So a patent needs to be the function of something is new. So that's why you have like, medications where it's a new formula and it does something new. So think about functionality versus look and feel. Trade secrets, I think pretty self-explanatory, something that's, so critical to your IP that you're going to keep it to yourself. So once the concept of patent and design registrations is that it allows society to progress. So by publishing the recipe for Panadol, whilst it gives, the makers a lockdown for 20 years of the patent life, subject to, there's some ways things can be extended and dealt with. Um, what happens is that everyone else then gets access to it and can build on it and can develop things. So it allows for sharing, but it allows someone to commercialize and be rewarded for their efforts. But sometimes a patent, knowing that it expires, some people want to lock down their IP and say, well, I don't want to share it. I'm not going to let anyone know about it. Going to keep it for myself. So that's the trade secret. And that's similar to confidential information. So often confidential information would be more like your know-how, your supplier list, your customer list, or your particular ways that you do your business. That's confidential information. Um, so they're the key, aspects of IP. That's sort of everything that I had in mind to chat to you guys about today. Uh, I've got a couple of questions that people have asked, so I might jump into those once they load. Let's see. So, they're not coming up, but I will. Someone asked, so if I have been trading with my trademark for a number of years, can I still register it? Yeah, absolutely. So even if you've already been running your business for a number of years, it's still worth registering it because if you want to protect your brand and stop other people coming in to use your brand, then it gives you that protection, even though you might already have that industry knowledge, industry goodwill. So are there any other questions? Feel free to post. If not, I've shared my contact details, and obviously you know them because you've been able to sign up. So feel free to shoot any questions through and we can follow them up after the fact. And yeah, thank you everyone for joining.